Oh, good. Our next speaker, come to find out that, well, let me tell you what kind of preempted me bringing this speaker on board. We had a gentleman down in Pueblo that got audited by the Department of Labor. He was fined $1,500 because his process servers didn't have their own websites, and his process servers didn't work for other process serving companies. And the auditor told him that the Department of Labor had decided to target process servers this year. Now, I don't think what he got dinged for that cost him $1,500 was worthy of $1,500, and he fought it and appealed it, and I don't know if he'd won. But what I want to share with you is that it's better to be in the know than to suffer a huge fine, a $5,000 fine, back taxes on every process server that you have or had in the past, and that can run you out of business. Laura Hazen, we were talking in the back by the refrigerator while Chris was finishing up. We actually served papers for her when she was with Ireland and Stapleton. She's since stepped out on her own, has her own law firm, Hazen and Klopman, and she's agreed to come here and speak with you today. Please give her a great round of applause to Laura Hazen. Thank you.
Thanks. Oh, my pleasure. No, I'm good. Can you find my PowerPoint? Is it in there?
Do we have her PowerPoint?
Hit next.
There you go.
Look at you guys having your act together.
No, it's not me, it's them.
Oh, okay. Fantastic. All right, let me just get set up here for a quick second. I'm afraid I'm going to make this microphone ring. Can I? Got that? You got enough? Okay, great. Steve, do they have the handouts? Or we're going to send those on? No, that's totally fine. I just wanted to know if they were going to follow along. Well, good morning. I guess it's still morning. On some level, I apologize to you for having to go straight from a CPA to a lawyer. I swear, we're terribly delightful human beings and considerably more fun than you think we are. Or maybe not, I don't know. So a couple things that and first of all, I want to thank Steve for all of his work in putting this together. It's rare, I speak all the time, and it's rare that I come into a conference where everything is set up and it just flows. So congratulations and thanks for that. Thanks for your work wherever you went, Steve. I really appreciate that. There'll be 3 handouts that you'll get when this is all done. One is sort of an informal memo that I put together that summarizes some of the most common independent contractor tests, just to sort of refresh your memory. There's another one on I-9 audits, and then there's another handout that I like to give out whenever I talk about different kinds of employment issues that goes through a number of things that you have to do as employers when you hire your first employee in Colorado. So those will come to you, so don't feel like you have to write every single thing down. It sort of depends on what kind of a learner you are. If you have to write things down to remember them, then by all means, scribble like a crazy person. But to the extent you'd rather read something later, those will be coming your way. So the independent contractor and employee dilemma is a trap. It's confusing. And I think whenever you're talking about a topic like this that is exciting and interesting to me because I'm a huge nerd, but may be terribly boring to you because you want to just get back to work and not have to worry about these details, I think it's important to understand why we're talking about these things today and what's going on. Why are we talking about these things today? The number one call that I get about independent contractors is not the IRS. As Chris, was that the CPA's name? As Chris was talking about, I get those calls a lot, but the first call I get is from the Department of Labor. It's from clients who are panicked because they've gotten a letter from the Department of Labor that says that they're going to be audited and they're going to have to address this issue. Why do we care about the Department of Labor? Not because they have a terrifyingly noble and scary seal, but because of the penalties associated with misclassification of employees. In Colorado, the Colorado Department of Labor will penalize you $5,000 per willfully misclassified person. And that's for your first offense. And if you have a second offense, and I'll circulate the slides as well, it's $25,000 for each offense. That is a lot of money. That is a lot of money. And then the IRS has the same kind of a scheduled $5,000 per violation for the first offense, and then after that there are treble damages for willful violations, which means that if they come in and find out that you had advice to the contrary and misclassified your folks, they'll hit you ×3 from the get-go. So it's always important to just sort of scare you at the beginning, to give you the adrenaline rush so that you'll focus on boring legal things for the next 45 minutes. Now the reality is that as business owners, you take risks every day. If you were interested in an industry where there were no risks and no potential liability, you probably wouldn't be doing what you're doing. I don't know what you'd be doing. Maybe you'd have a cupcake shop, or you'd be at home knitting or something, but you didn't choose to do that. You chose this industry for a reason. So why do we take risks? Why don't people just slap everybody on payroll and treat everybody like an employee from day one? Because the people you hire want that. They want to be independent contractors. They don't want to have to deal with that stuff. They want the freedom to go, and because you want it. You want that. Why do you want that? Because there are a number of benefits. When you are working with independent contractors rather than employees, you don't have to comply with employment laws, the Americans with Disabilities Act, Family and Medical Leave, Title VII, which is the federal statute that prohibits discrimination in the workplace. It can really cut down your potential liability. You also don't have to deal with payroll taxes. You don't have to deal with unemployment compensation, workers' comp benefits. All that is off your plate. So that's why you want to do it that way, because you want to come to work and do your job and not worry about all this additional paperwork. If you liked paperwork, you would have been a CPA or a lawyer. That would have been super fun for you. So that's why you don't want to do it. The other thing associated with, if you go down the road of having employees, you're going to deal with payroll taxes, with overtime, so that's more than 12 hours in a day. You've got to have people track their hours. That kind of paperwork can be a pain in the neck. You may or may not decide to offer them benefits, and you have to worry about minimum wage, and then frankly, you're going to have to deal with the legal fees associated with making all of those decisions. So why do you not make that decision? Why do you decide to bring people on payroll? Because you love a good audit and you want to finish your audit with big fat gold stars. When those creepy and antisocial feds come into your building, you want to be able to say, look how great I am. I will pass this audit with flying colors. That's why you want to do it. Also because talking to lawyers is super fun. We're terribly delightful. So here's what I suggest you do. I know you all have paper in front of you. I would suggest that you make a big T column in front of you. Think about your process servers and put a column that says, one side of the column that says employee and one that says independent contractors. You're going to do sort of a little mini audit for yourself right now. So I'm going to throw out all the factors, well, not all of them, because I couldn't do that, we'd be here all day, you'd really be asleep, but I'm going to throw out some of the main factors that the feds, IRS, and the state use to determine whether an individual working for you is an independent contractor or an employee. And you're not going to fall all the way in one category or the other, because that's just not how life works. So have a column for employees, have a column for independent contractors, and then as we go through these factors, make a list. So write down, okay, the way I operate right now, this factor supports the fact that my process servers might be employees, and this one supports they might be independent contractors, and that will give you sort of a visual at the end of where you're falling, and there might be a way to shift some of those from one side to the other if you decide that you want to manage your business one way or the other. All right? Okay, so first, let's look at the Fair Labor Standards Act tests. Sorry, one of the downsides of being a lawyer is you really want to get these things 100% right, so I'm going to give you these status. So the Fair Labor Standards Act is the federal statute that regulates minimum wage and overtime. The State Department of Labor, so that's the Federal Department of Labor. The State Department of Labor in Colorado determines when payments are made, so when money is earned, vested, and determinable, and when you have to pay folks. The state folks also regulate meal times, break periods, things like that. So the feds, we care about minimum wage and overtime. The U.S. Supreme Court has identified a number of factors under the Fair Labor Standards Act to determine whether someone's an IC or an employee. Number one, the extent to which the services are rendered are an integral part of the principal's business. So if this person is doing something that's important for you, a process server versus a plumber. You may have a facility like this, and you may occasionally hire a plumber to come in and fix your toilet. Is that integral to your business? Well, in a way, people have to go potty, but not in the same way as a process server. So are they integral to your business? The permanency of the relationship. Is that person going to be around all the time? Do they regularly get work from you? Or do they just sort of come and go? Is it you just call them every once in a while? The amount of the contractor's investment in facilities and equipment. If you have a person who brings their own computer, who is using their own tools or has put money into the business, they're probably more likely to be an employee than an IC. This is one of the biggest ones, the nature and degree of control by the principal. If you call up Bob and say, here Bob, I want you to serve this person here, here's the packet, see ya, and that's all. You don't control how they do it, where they do it, what method they use, what goes on, then that person is probably more likely to be an independent contractor than an employee. If you say you have to fill out this form and this form and this form that are purely for your own internal use, the certificate of service being different, obviously that's what they need to fill out. But if you require them to do things a particular way, you say you can only serve these folks at work, you can't do it at home, or it has to be these hours or something like that. So the nature and control. The amount of initiative, judgment, foresight, how much independent judgment is that person making? If they are free to do things the way that they want, they're free to use their own personal judgment, more likely to be an IC than an employee who you're the boss of them. And now remember that these are factors that the IRS uses for every industry, so not all of them are going to apply to you, but I'm going to give you all of them anyway, just because that's what we're going to do. And then the degree of the independent business organization and operation. And this is where the comment that Steve made about the process servers having websites. Do the folks who do your serving have their own business cards? Do their business cards have your name or their name? Do they have their own website? Do they have their own bank accounts? Do you pay a company name or an individual name? If you're paying an individual, smells like an employee. Paying a company smells like an IC. Do they have their own office? Do they, so all of those things. How are they actually their own entity, or does it really feel like they're one of you? Things that the Department of Labor doesn't care about, so these don't go on your piece of paper, where the work is performed, whether the individual maintains licenses with the federal government, the time or mode of paying, which is interesting because some other department, you'll hear that, it's different later, or the absence of a formal employment agreement. They don't care about that, the Department of Labor. Other people will disagree. Any questions about that one so far? I would suggest that we'll go through all these boring factors and you can sort of analyze it. I'll get your question and then we'll come back because I want to make sure that I'm answering your questions because I talk about this all the time and I hear myself talk all the time. Do you have a question?
So, if I have 10 papers to serve in a row, and I have an independent contractor, and I say, I'll meet you at Colfax. I'll meet you at Colfax and Havana at 10 o'clock this morning and give you these papers.
Right.
So my guy meets me there. I give him the papers,
Yep.
and I say, have a nice day. Oh, there's 2 here that have to be served by tomorrow night at 10
Right.
p.m. Is that giving him specific direction on how to do it, or just a varied time scale when he has to do?
That's a really good question. Did everybody hear it? I'm happy to repeat it for the recording, or did you get it? Okay, so the question was if you give specifics about when something is due, something like that, is that something you can do? That's absolutely appropriate. Think about it, if we're hiring a plumber and I had a broken toilet and I said, I'm having an event here next week, I need the toilet fixed by next week, that doesn't change the nature of our relationship. Similarly saying, when you're done, this is the kind of form that I need to file with the court, because those requirements are almost external. That's not you being a control freak and saying, you have to wear a shirt with my logo. Not that that would be a control freak, but you know what I mean? You have to wear a shirt with my logo, and you have to go in a brown car, and you have to do it. That's not you setting those kind of parameters. That's what the client needs. So it's sort of a pass-through requirement. Does that make sense? Okay, great. All right, let's talk about the IRS. Who doesn't love talking about oh, yes. You passed. Here we go.
Yes, you mentioned something about requirements that have to be met by an independent contractor.
Yes.
If I give him my papers to serve, it is a requirement that he fills out a specific affidavit of service.
Yes.
Does that make him
An employee?
employee?
No. If you say, I need you to file this, I need you to fill out this affidavit of service so our client can file it with the court, that's different from saying, I need you to fill out this form for me internally so that I know you did it, the right way, and because this is how we keep our things, and you have to, for example, employees tend to show up somewhere in the morning and they stay there and they attend to whatever duties, and they're not free to come and go. If you have a job, you probably are at your job. Independent contractors can sort of come and go. So it's those kinds of controls, but that's a good question. I do not believe that the requirement of an affidavit of service is going to change that relationship because frankly, absent that affidavit, they haven't performed their service. Then your client isn't getting what they need. All right, so let's look at the IRS next. This is one of the most common investigations done by the IRS. And let me just sort of step back a little bit. What Steve said about the fact that the feds are targeting process servers is accurate. The IRS and the Department of Labor on the federal level will issue press releases every year, and they'll identify the industries they're going after. That doesn't feel very good when you're on that list. I'll tell you the folks who are always on that list are construction, landscaping, restaurants. It's folks who are often employing workers with questionable immigration status or who may be here in an undocumented, in an undocumented way. Also, recently they've been targeting childcare providers, daycares, things like that, hospitality industry. Occasionally they go after computer professionals as well because that's somewhere that folks can be a little fuzzy. And now you all. So why do they do that? Well, every time you have an administration change or there's some new initiative that the feds or the state government is going to take, they have to find the money. And what they've decided in the last couple decades is where are they going to find the money? Employers, which is terrifying because if you want to boost the economy, small business is kind of the way to do it when you look at the statistics. Small businesses employ more people than large corporations, so it seems sort of silly. But that's why they're doing it. So the federal government and the state, they are looking to enforce more and more fines against employers. That's the Debbie Downer moment of my day. I apologize for providing. Don't shoot the messenger. All right, so the IRS. What's their test? So they have a 20-factor test. If the people you're working with must comply with your instructions about the work. Again, the fact that you're saying I have to fill out an affidavit or you have to meet me here to pick up the paperwork or it has to be served by this time, that is some evidence that that person might be an employee. I don't think ultimately that that's going to flip it because they're not really performing any service without that. This is a good time for me to say, I'm not providing legal advice. This is merely a general discussion of legal principles. To the extent you feel that an attorney-client relationship is being formed, it's not. Even if I already represent you, this is not legal advice. Okay, small disclaimer. As we continue with our general discussion of legal principles, I'm heavily regulated too. If your people receive training from or at the direction of the employer. So if you say, before you can come work for me, you have to go to ABC process serving school and learn the way they do it, and you have to do it that way. Or if you direct them to go. If they provide services that are integrated with the business, which your folks are, so that's one bad fact for you. If they provide services that must be rendered personally, and this is something that's interesting. If you hire somebody and say you have to serve it, do you care if their dad does it? Do you care if their brother does it, or do you just care that it gets done? That's one factor. If it has to be rendered personally, if you're hiring Bob to do it instead of Bob's Service Inc., that's a question. If they hire, supervise, or pay assistants for you, so if your process servers come in and are in charge of supervising some sort of administrative office staff, that would be a bad fact. Bad being they're more likely an employee. I don't really think that's bad, but for the purpose of this discussion, bad. If they have a continuing working relationship with you, if this is the only person you ever call in Aurora, the only person you ever call, then that suggests they might be an employee. If they must follow set hours of work, they have to answer your call between 8 and 5. They have to be available between 8 and 5. They're designating time specifically for you. Here's a tricky one. If they work full-time for you, and this is one of the big ones we'll talk about on the state level, if you are the only person they work for, then they're much more likely to be classified as an employee. If they work on your premises, you know, they always come and this is their office. They're allowed to use this office, and it's their designated space. They work on site. If they must do work in a particular sequence, before you serve, you have to look this up, you have to look this up, you have to look this up, because that, again, is sort of telling them that they have to use a particular process as opposed to get it done, and then I don't worry about how you got it done. Must submit regular reports to the employer. If you require them to check in every Monday, Wednesday, Friday at 9 to see if you have any work for them, then they might be more likely to be an employee. If they receive payments at regular amounts at regular intervals, they get $400 a week. Or do they get paid per job, which can ebb and flow. They rely on you as the employer to provide tools and materials. This is a big one. It's one thing if you're handing them the stack of documents to be served, but if you're providing them with a car or a computer or other tools that they need to get the job done, they're more likely to be employees. If they cannot make a profit or suffer a loss from their services, they're more likely to be employees. Think about that. That's kind of complicated. If I'm an employee of an organization, my compensation is set. It's determined either by the number of hours that I work or by a set salary. If I have my own business, then I'm going to have my own insurance, I'm going to have these things, and if I don't get enough work from you, I could suffer a loss. Or I have my own insurance, I do a ton of work, I do great work for you, you continue to give me work, I can make a profit. So if there's some ebb and flow over there, then they're more likely to be an IC. If they work for only one person at a time, if they don't offer their services to the general public, do they have websites? Do they have brochures? Do they market with other law firms or other entities who might need their services? Or are they really kind of a one-man show? Are you really the only ones keeping them busy? If they can be fired, then they're probably an employee, because that implies that they had some sort of ongoing relationship that could be terminated, as opposed to just I call you when I need you. If they can quit at any time without incurring liability, that's a tough one for me, because on some level, employees can always quit, right? So employees can quit, but so can independent contractors. So do you have some sort of contractual relationship that says you have to give me a certain amount of notice or something like that? So that one, I don't really know that I know where the IRS would let that one fall. That's one of the things they threw out in a Supreme Court decision, and I don't really know what it means. If these things were clear, I wouldn't have a job. So I should probably be thankful for that. This one makes no sense. Great for me. Bye. All right, so those are the tests for the IRS. Any questions about those clear as mud requirements? Yeah.
So I think maybe a lot of us here do. Our company, we use a specific software for our services.
Okay.
And our software is tied in with smartphone applications. And it's a big selling point for us to go to attorneys and say, we use this software, and because of that, you gain these benefits from having our serve your papers.
Okay.
We want whoever we use to serve our papers to use that app on their smartphone.
What does the app do?
The app tracks the date, the GPS location, the time of the service. It gives us a 1-minute audio recording of the service.
Cool.
It generates the affidavits, and it generates our invoices.
I really like that.
I do too.
As someone who has people served, that makes me happy.
And our clients can also log in through our website and see in real time when we've performed attempts and when the document's served, and they can download their own invoices from our website. So if I hire somebody to do it, if it's an occasional service, if I get a service for Salt Lake City and it's the one person out there, whatever, we don't require that.
Okay.
Yeah, I'll get with you later. And but if it's somebody that we use regularly, we don't. again, we don't require them to be exclusive to us,
Yeah.
but we do ask them when they're serving our papers to use that software.
Mm-hmm.
How does that fit in? Are we kind of sticky right there, or?
That's one bad fact. To the extent you want to keep them ICs, that's one bad fact, because you are requiring them to use your particular software, which isn't necessary for the client. You know, it's not, the courts don't require that you use that.
No.
But it is, it's one bad fact. Do I think that if everything else were pristine, that one bad fact would tip you? Probably not.
Okay.
Not
Alrighty.
providing legal advice, merely having a general discussion of very fast words spoken. But no, I don't, that, you know, when you think, that's why I suggested the sort of the T account for, because it's going to be kind of a weighted thing, right? And candidly, and this is probably the least rewarding thing I'll tell you all day, is where you fall on that spectrum is in large part going to depend on who your neutral is, on who the person is that's investigating you, and what their personal views on it are. That means you're trying to sort of set up the best situation you can, being as safe as you possibly can, understanding that you may have a complete wacko making your decision on that moment, and they might go somewhere totally different, and then hopefully you have appeal rights and can try and negotiate it, but you can't prepare for that. So the way I view my role as an attorney when dealing with these issues or anything else is that I can tell you this is the least risky thing you can do, and this is the most risky thing you can do, and then you as business owners decide where you want to fall. You decide where the cost benefit is for you, and then, you know, either I help you get to that point or you decide what you want to take on. No problem. All right, so let's move on to the state. So unemployment compensation. This one, I had an employer who had teachers, coaches that were that worked for them and provided sort of tutoring services, things like that. She had a cadre of probably 60 people on her payroll, treated them as independent contractors, and then one of them was terminated or ended her contract in another job. So she had another job. She was fired there or quit, and then applied for unemployment compensation and listed her work, listed her income from this employer, my client, on her unemployment application. Because of that, the State Department of Labor, the unemployment, they came down on her and said, you've misclassified everyone. And the question was, does she have to pay unemployment benefits or not? Because and it became a very important issue for her, not because this one person would have cost her all that much money, but because then once this person flips, then everybody does. Because one of the biggest things you can do that's the most risky on this side of the fence is have a whole bunch of people who do the same thing and classify some as employees and some as independent contractors. That is very risky. Because the question is why? Why are they all that different? And so the safest thing to do is treat an entire category of folks the same way. So that was what we went with that. Now the interesting thing about the unemployment compensation is there's a statute, and it specifically says that there are these 9 factors that I'll tell you, and the court will consider, in this case hearing officer, will consider these 9 factors. However, if you have an independent contractor agreement that says X, Y, and Z, there's a presumption that they really are independent contractors, and then it becomes the employee's burden to prove that they were an employee rather than the other way around. So if you don't have an agreement with this special language in it, then the assumption is that they really are employees. So this is where paperwork is great. See, lawyers are fun. We like paperwork. It's super great. So what are those factors? Let's look at the factors. Number 1, the 2 biggest ones that would be your burden if you didn't have an agreement, or if you had an agreement that didn't include the magic words, you would have to demonstrate by the preponderance of the evidence, which means like more than 51%. It's not beyond a reasonable doubt like you hear on CSI. It's the civil standard. It means by a bunch. That this person was free of control and direction in how they performed the services. A common test, we've heard that before today, and that they're customarily engaged in independently established business relative to the services performed. So what does that mean? It means they do this for other people. It means they have an actual business. The questions that the hearing officer asked in that case when I was representing my client was, are they required to wear anything in particular? When this person goes for a tutoring session, do they have to wear ABC Tutoring logo on their shirt? Or can they wear whatever they want? If they want to give their card to the person, are they giving an ABC Tutoring card, or are they giving Jan's Tutoring? Are they giving their own company's card? Do they have a bank account? Have they incorporated? Do they have their own insurance? All of those things that are sort of the trappings of having a business. The biggest thing he wanted to know was, are they doing this for somebody else right now? Do they have other clients? Think about it as a plumber. Does that plumber have other people that they're doing this for? Is it possible that that plumber is having a dry spell and that right now, no, they're really just doing work for you? Fine. You know, to the extent this week is a slow week or this month is a slow month because nobody deals with plumbing in January, making that up, then that's fine. But generally, they have other people, you know, over the course of a year. Those were the two big things. So if here are the other factors they looked at. The individual is allowed to work for other employees or other employers. What does that tell you? It tells you that you can't have a non-compete with an independent contractor. Can't do both of those things. Can you have a statement that says that the process server that you are hiring can't use your trade secrets or your relationships? Sure, that's fine. To the extent you have a secret sauce and you want to protect that, or you have a client list, or you have a form you're particularly proud of, you could say you can't take this and go start your own business and compete with me directly. However, to go down that route to prove that you have trade secrets, that smells a lot like you're asking them to do things in a particular way, which creates other problems. That they're paid a fixed or contract rate, not a salary or hourly rate. Although the feds don't care about that, the state does. So they want to know that you get X number of dollars per job or per attempt or something like that. They kind of want it to feel like piecework. That the employer does not oversee the actual work or instruct them on how to do it. So that's where one argument you could make with respect to your software is you're not telling them how to do it. This is simply the mechanism. This is your tracking system. This is just how you are able to communicate with your clients. That again, you're not instructing them how to do it. You're not saying you have to make 3 attempts before you come back and say it wasn't served, or you have to try on Mondays or something like that. So you can make those arguments. That you as the employer provide no or very minimal training. That you pay the individual through their trade name or business. It's possible in Colorado to be a solo practitioner that you don't incorporate. At the same time, it's really easy to register as an LLC. It's really not hard. It's a pass-through entity. It's not hard for your people to go online and register. It costs like $17. It's not that hard. That the work is not ended during the contract period unless the individual violates the contract or produces results that did not meet the contract specifications. That tells us that the state does allow you to have contract specifications. You're allowed to say, perform this work in a workmanly way, in accordance with industry standards. Does that mean that this person can show up drunk to serve somebody? No. You can say, no, you can't do that. You can say, you have to behave appropriately. You don't serve somebody and then drop the F-bomb and punch them and leave. Like, that's not how we behave. So you're allowed to have some basic standards of human decency and of sort of industry standards. But someone might serving someone might be different from, delivering their mail. So it's going to be industry standards. So you don't have to require them to act like a kindergarten teacher. You can figure that out, whatever makes sense for you. That you as the employer do not control the individual's performance besides a completion schedule and a range of mutually agreeable work hours. So you're saying basically, we need it by this time. And that the employer and the individual's businesses are separate and distinct. So they're not you. So the document that I suggested, if you're going to create an independent contractor agreement, the information that you need in there, here's the magic sauce, and I can email you the statute if you want. You can Google, it is Colorado Revised Statute 8-70-115. And so what that contract has to say, if you just Google it, you'll find it. That the person who's signing the contract, the employee or the independent contractor, is not entitled to unemployment insurance benefits, or that somebody else provides it. So either you're not entitled to it from us, or if you're going to get it, it's going to be from somebody else, like your own company. That let them know that they have to pay their own federal or state taxes. And then just include any of the other factors that you can, any of the other factors that they identified. That needs to be, and here's the weird part, this is where I look at this and say, what are these people in the legislature doing that they're putting this in statute? That language has to be in a larger typeface than the other contract provisions, and it has to be bold and underlined. What? So you can have all of the perfect stuff in your contract, but if it's not in a larger typeface, bold and underlined, then it doesn't count, you don't get the presumption. That's goofy. Yet, this is the law. Okay, so the other test that I want to talk about, which is sort of feels the same to me as that one, would be the workers' compensation statute. There, it's almost the exact same 9 factors. They have the exact same language about the bold and underlined and larger typeface section. Let me give you the statutory cite for that, just in case you feel like geeking out. And that is 840-202. So for the workers, to make sure, and the benefit of this statute is if you comply with this statute, then that person can never make a claim against your workers' comp policy, which is it's a useful thing. So you have the same factors, the same magic language. However, under the workers' comp statute, the signatures on the agreement have to be notarized. What? Why would they have to be notarized under workers' comp and not unemployment? I have no idea. Somebody fell asleep when they were drafting the statute, but they have to be notarized. So there's that. So other tests that I think are important, let me see. I think that's pretty much it. So to sum this part up, the 3 main issues that will determine if you were going to sort of distill all that down, the question is, do you have behavioral control over this person? Do you have financial control over this person? And just really, what's the type of relationship? What's going to happen is the feds or the states or a judge, whoever's looking at this relationship is going to check their gut. They're going to say, what does this feel like, and how are you really treating them? You could have a beautiful independent contractor agreement. I do draft some really glorious independent contractor agreements. They're lovely. It could be perfect, but if you ignore it and do something totally different, then that piece of paper is not going to save you. So they're going to look at the realities of your relationship. And the existence of an agreement is going to be one of those factors, but if your agreement provides that X, Y, and Z are going to happen and you don't ever do it, then it's not going to protect you. I say the same thing with employment policies. I draft a great handbook. It's true, but I can draft you a perfect handbook, and if it sits on the shelf, and I come in and say, "Great, what are your employment policies?" and you go, "Well, it's got to be something in here somewhere." I'm like, I drafted that 5 years ago. No one's ever even cracked it. It's not going to help you. So don't waste your money if you're not going to actually follow through. Is my point there. So what do you do to protect yourself? Sorry, what do? You audit all the things. You look around and you try and figure out what's going on, and you look at your documents, you look at the way you're actually behaving, and really make a realistic assessment of what it is and what you want to be. Some of my clients really want the control over these people, and so they're willing to go through the headache of hiring an employee, because it's really not that big of a deal, to go through all of that stuff in order to be able to control and or micromanage what that person is doing. That's worth it to them. Or they're the kind of person who's driven by anxiety and they just don't want the unknown out there, because having independent contractors can be a significant unknown. And so it just sort of depends on what you as a person, are you going to wake up at 3 in the morning and say, maybe they're an employee? Then maybe you need a vacation, but you might be that person, and if you are, you should probably have employees and not independent contractors. And likewise, if you want to really make sure that they're wearing your logo, if that's an important part of your business, that those people go out and when they're interfacing with your clients, with lawyers, and they're interfacing with other people in the community, that they present themselves in a certain way. Do you want to have a dress code? Do you want to require them not to have big facial tattoos? Do you want them not to have their foreheads pierced? What do you want to do? How much do you want to control what they look like and what they're doing? If you want to control that, then they're employees. If you don't, then maybe there's room. All right. So a couple other things that I want to address. So the business documents, it's important to make sure that if you do have independent contractors, that you do have some sort of employment, or that you do have some sort of independent contractor agreement. If they're employees, you can get by with a job description. I always say that if you're going to spend a little bit of money on employment advice, the first thing to do is have a job description. Not only does it create predictability between you and the people that you're working with, so everybody understands what's going on, it makes performance reviews easier, because you're like, see how I told you had to do this? You didn't do that, so knock it off. You can, you point to something, and then everybody has an understanding of what the expectations are. Similarly, if somebody comes to you and says, and this is a whole separate lecture, that they are disabled under the Americans with Disabilities Act and they're an employee and they can't do their job because they're disabled, and their disability is, I got this one last week, that they can't show up on time. You can say, well, unfortunately, in your job description, one of the essential functions of the job is that you come here. So that means we can't accommodate you. Or I had this one too, that somebody claimed they were disabled and they couldn't get along with other people. Okay, so the fact that you're walking into the lunchroom and calling people crazy names and, acting out, that's simply not acceptable here. So, interacts well with other people. You can't tell clients to F off. You just can't do that. So if you have something like interacts appropriately with clients, then you can lay that down there. So I do like a good document. The other thing to pay attention to is that once one of the federal agencies sort of starts getting their claws into you, what they do is they talk to other ones. And you can avoid this by a couple different ways. First of all, never ever make a mistake under federal law. Okay, so that's good. That's a great option. Door number 2, assuming that you're human and sometimes do make mistakes, is to make sure that you have a document plan for where your documents are and what's going on and when you destroy them. Those are 2 big important things. So for your I-9s, that's the document that folks fill out to determine that they're legal to work in the United States. You don't want to put those in their personnel file. You want to keep them in a separate binder. This is not legal advice. 1 tab for current employees, 1 tab for past employees, 1 tab for sort of questionable if you get a no match letter or something, which can sometimes happen. I have one client, Michael Connolly, and he gets no match letters constantly because there are a lot of Michael Connollys in the world. He lives in Boston, so it happens a lot. His dad is Michael Connolly, so he's always getting his dad's tax returns. So he's totally legal to work in the United States, just his social security number gets messed up sometimes. Then you also need a tab for the Colorado affirmation of ability to work in the United States as well. So you need that tab too. So if you have those in a separate place, when the IRS comes in and says, we're doing an I-9 audit, you hand them your binder. That's great. You don't hand them all of your personnel files, because if you hand them all of your personnel files, they came in to look at this one issue, suddenly they're going to open up the whole Pandora's box of everything else here. And unless your records are 100% pristine, which nobody's are, I dare you to do an I-9 audit at a law firm, it's a nightmare, they're going to find something else. So you want to make sure that you have an understanding of how to store your documents and what you want. Number 2, you want to insure around any risk that you can. That looks like personal umbrella policies for you as an individual. That looks like your own general liability policy for your entity, and then anything else that you need. Corporate formation, as Chris, as a CPA, as he said, is one form of insurance. It's one way to make sure that if I'm going to sue you, that they can only get these assets and not these assets. And if you're commingling funds, then you're going to open that up, pierce the corporate veil, open all these assets up. So your corporate formation and observing those corporate formalities is another form of insurance to sort of protect your liability. I talked briefly about files. I also think it's important to make sure that your record keeping with respect to employees and your record destruction policies are established and that you follow them. One of the things that happens when I am talking to an employer about a potential, say, age discrimination complaint, I come in and it's not uncommon for them to say, you are going to be so happy. We have all the records from everything, from when we started this company 30 years ago. Here, we didn't throw away a thing. Well, I guarantee you that somebody's whined about something in the last 30 years that smells like what the plaintiff is now whining about. And so now to a jury, it looks like, all hell's breaking loose in your entity instead of just we had 2 people over 30 years, which is pretty great. You're allowed to destroy most employment documents 3 years after the person is gone. General rule, generally 3 years. Some you're required to keep later, workers' comp kinds of things, some OSHA issues. So you would want to get sage legal advice on that to make sure you have a document destruction policy, but don't keep things longer than you need them. For example, if the Department of Labor comes in to audit your independent contractors or employees, if you have people you haven't used in 2 years or people who are no longer with you, you will still get those $5,000 a person fine just because you didn't throw the document away. So you want to make sure you don't keep stuff you don't need to, again, keep your liability to a minimum. Another thing that I think is easy to sort of blow off, but I think is important, is to make sure, does everybody have a spot where they put the big employment poster? You go online and you click employment posters or whatever, and there are a lot of different companies that will put them together for you. Often it's on a bulletin board in a break room or something like that that says under the Fair Labor Standards Act, these are your rights. You don't ever have to take a polygraph. Here's our immigration policy. It's just the standard postings that federal and state statutes require you to have. The reason why I like those, even if you don't have employees, is because those are independent violations. So if you don't have the right postings, that's another reason they can tag you for extra money. So if they come in and say, you know, actually all these folks are employees, then at least you can say, well, we weren't hiding anything. You know, we weren't hiding anything. And look, we even posted the regulations there. So it's right here. It costs about $15. They're not expensive. Just put them up on the wall. No one will pay attention. And then make sure they're updated every year. Short and sweet insurance policy. Another reason why that's important is because particularly under the IRS, they have what's called a safe harbor provision, which basically means that the IRS is probably not going to fine you for willful noncompliance if you tried hard. And what does that try hard mean? It means if everything is sort of as put together as it can be, and you sought advice from somebody, you sought advice from a lawyer, you sought advice from a CPA or something, and you worked through it, and you did what you thought was right, then at least you can avoid a lot of the penalties. You'll still have to pay back taxes and things like that, which can be expensive, but they're not going to slap you in the same way if you try. And part of trying is making sure that employees understand their rights. I keep gesturing over here as if the poster is here. The imaginary poster right here. Because you're saying, I wasn't hiding anything, I wasn't lying to these people. And so if you have, for example, independent contractor agreements that say you're not entitled to unemployment insurance, you're not entitled to workers' comp insurance, and you promise as an independent contractor to tell me if there ever comes a time that you're not working for other people. Then suddenly you say, you know, plausible deniability. How was I supposed to know Bob stopped doing this for other people? I had a contract with him where he was supposed to tell me if he was only working for me, and he never did. So how was I supposed to know? So this is the sort of Mickey the dunce, I don't know, like when my 5-year-old says to me, like, I didn't realize I had to wear underpants. It was sad, you know, I was like, oh, yes, you did. But, you know, she had plausible, you know, she's like, I thought it was the weekend. Okay, that was her, well, we still wear underpants on the weekends, but that was her excuse. She had a reason, all right, I won't get too mad, but we wear underpants on the weekends. You know, so that way, hopefully, you'll have that reaction from the Department of Labor. You'll say, I'm sorry, I thought we were doing everything right. We had the statutory language in our agreements. We posted our employee rights. You know, we thought everything was fine. We talked to a lawyer. We audited our internal procedures. I guess we were just wrong. That way it becomes sort of a difference of opinion or a swaying of the tides, you know, that different administrations are more concerned about it than others. So at least you have that sort of legit answer. So try and take advantage of the safe harbor. So did anybody actually do the little T-chart? Did you figure out, what do you think, employees? Independent contractors? All right. Yeah. Shoot.
Sorry. I have a question on what about when you're hiring these independent contractors?
Good question, because how are you going to find these people, right? So if you're looking at these three things, the behavioral control, financial control, and this. So maybe your ad says, looking for businesses to contract with your entity name to provide services, you know, to provide services. Looking for individuals or services in the business of doing what I'm asking you to do. If it's an individual and they've never done this before and you're the only person they're doing it for, then they're an employee. Now, what you could do is you could roll the dice on that one and say, I'm going to hire you, but in order for me to hire you, you have to form your own entity. You have to get your own insurance. You have to do this and you have to do that. I'm going to have you sign an independent contractor agreement. And because I understand you're new to the business, in my experience, it takes about 3 months for you to find somebody else to do this work for. And so I'll give you 3 months. And so that way, if the Department of Labor comes in, you say, it takes a while to get ramped up. This person was legitimately starting their own business. We just happened to be their first client. Maybe you partner with somebody else in your organization and say, hey, I've got a new guy. I think he's going to be great. You know, he's forming an entity. Will you, agree to throw him some work too? And then you scratch each other's backs, and it's great, as long as it's true, and you are actually doing that. But that way this person, has this, you can say, for example, if you're hiring someone who doesn't know what they're doing, one great way to learn how to do this is to take this course. Here are 5 different ways, 5 different ways you can learn how to do this effectively, or people you can talk to. You're not requiring that. You're not even really suggesting it, you're just being helpful. You're saying, if you want to, go ahead. Would I put that in writing? Probably not. But to help each other out is one thing, but to do something else is different. Does that answer your question? So I think to the extent that you can put out a carefully worded request for a contract instead of a job description, maybe try to be careful about your language. And then when they get there, say, here are the names of 5 different CPAs that I like, here's 5 different, attorneys that can help you incorporate, or here's the website. If you go on to the Colorado Secretary of State's website, sometimes you can find those flyers like how to start a business in Colorado. Maybe you just print something like that off and say, I'm going to pay your entity and I need proof of insurance within X amount of time. So again, you sort of decide your risk. Yeah?
I was just wondering about the idea of hiring them through like a labor service, where they just sign up through the service and then you hire them through. I do that with some stuff in my hometown on another business that seems to work okay there. How about process serving? So
with the labor service, who writes the check to the individual?
The labor service would write the check.
The labor service. That's a fine way. That's a fine way, because then they're not your employee at all. They're someone else's employee. So then what you have is you have some sort of contract with the labor service that says you're going to sort of rent me people, but you're in charge of the unemployment, you're in charge of workers' comp, and just make sure your contract with them is very clear about where the liability goes. You're always going to be liable if you punch the guy in the face. That's really, you can't write around that. But if that person makes unemployment claims because their employer is the labor service, then you should be in a different place. Yeah. And then I see you too. Got you next.
Okay, I know I already asked a question. I don't want to monopolize your time here, but let's say I have a nephew in college, and just for some extra money, I send him occasional and sporadic work.
Yep.
But I'm the only one that sends him process serving work. But it's not steady. It's when I have something in his area and when he's available, I send it to him. When it's due or before it's due, he sends it back. That's it. I don't control any of that other stuff, other than we ask him to use our software.
Yeah.
I'm the only one he's doing it for, but I don't say he has to only do it for me.
Right. He's probably an employee, is the bad news there. He probably is a part-time employee. And so you just have to take the risk. And the risk is he ever going to sue you? Probably not. When you bend the laws with family. I'm so not saying this out loud right now. I'm not. When you bend the law with family, it's a different level of risk than with other people. But then if you get somebody else who's squeaky and they do an audit of everything, then he's going to be wrapped into that and you may have to pay. Yeah.
Do you have a independent contract that I can purchase from you?
Yeah, it's funny you'd ask that because I totally do. It was like I paid him to ask that question. Isn't that funny? Yes, I'll leave my cards over here, over by Chris's. Any other questions? I'm between you and lunch, and that's a dangerous place. The only place worse is to be between a group of people and their happy hour. So that's not good. I know, right? My people are luscious. Yeah.
Does it make any difference if they have another part-time or a full-time job and they're just doing yours on the nights or weekends or something?
So the question is, if they have another full-time and they're doing yours on nights and weekends, is it in this industry? No, a totally different industry? No, then because you can have 2 employers at the same time. So if they're teachers during the day and they do this nights and weekends, then they're probably your employee, or more likely to be found to be your employee. If they do this full-time for another agency and then they moonlight with you, then they're probably an IC because they're customarily in this industry. One more question? Yeah.
Is there a problem with them signing an affidavit of service with your company name on it? Is that directly having them as an employee?
That's a good question. So is it one fact that they may be more likely to be found an employee if they sign an affidavit of service with your company on it? No, that doesn't freak me out because you are the ones who have the contract with the law firm or with the entity that's asking you to serve. And so your client wants to see your name. And so they're signing it as an agent. So the whole law of agency is something I could bore you with for days. That just sort of, when does somebody else have the right to act for you? And so when you hire an independent contractor, they're allowed to act on your behalf, specifically on the assignments you contract with them for. They can't go open a bank account in your name. They don't have general powers, but they are in that moment serving on behalf of you. So I'm okay with that.